terminology. In this new regime, attachment doesn't mean that at all. It means the process whereby the security agreement becomes enforceable between the grantor and the grantee, and that will happen relatively early in the piece, almost immediately, as we'll see. The parties can agree to defer the time at which attachment occurs, but the court and the bill will not allow you to do that just by using the words floating charge. You have to make an express agreement to defer the time of attachment. If you do that, that's fine. But generally speaking, attachment will occur as soon as the requirements of Section 61 of the bill are satisfied, and we'll look at those in a moment. Perfection's a new term. It comes from US bankruptcy law, and it's not the same as crystallisation. It's the process whereby there'll be a separate regime dealing with water rights and tradable water rights and securities and water rights. Fixtures were included in the original version of the regime. They're taken out of the current version of the regime. They will be excluded. And that's again a political compromise between the Commonwealth and the states. The states want to retain control over fixture law. God knows why, because it's a mess. And it would have been better to include it in the new regime. The states will also retain control over some licences. Now, some licences are included in the new regime, some are not. Under the new regime, it's possible for the states and territories to carve out certain licences out of the new regime. They can, for example, say, we don't want gaming licences covered or liquor licences covered by the new regime. They haven't done that yet, but there's provision for that to occur. Other licences are included, and if we look at the case law, the voluminous case law in Canada, we'll see that the case law indicates very clearly that things like taxi licences, nursing home licences, fishing licences and so on are personal property for the purposes of the regime. And of course, the general proposition is that the more control that a regulatory authority has over the transfer of a licence, the less likely it is that that licence will be personal property. So if they have the security interest becomes enforceable against third parties. It's not absolute protection. It's the best form of protection you can get, but it's not impregnable. There are some ways in which other parties can get in under the guard of a perfected security interest. Extinguishment is familiar to you as Victorian lawyers under the Chattel Securities Act. It's the process whereby a security interest is extinguished and clear title is conferred on a third party. And there are what might be called purchaser protection provisions for parties who deal with the debtor or grantor without actual knowledge of a breach of a security agreement. And they will take a clear title if the transaction occurs in the ordinary course of business. And there's a lot of case law about what the ordinary course of business is, Canadian and New Zealand case law, and there's some guidance in the new bill. Now, you'll be familiar with the term ordinary course of business from preference law in insolvency, but that's not necessarily the same concept. It's probably closer to the phrase ordinary course of business in the context of a floating charge than it is to preference law. But there's a lot of guidance in the book from Canadian case law, and isn't it a beautiful baby? I'll just rock it. Sometimes it will change. All babies need changing, don't they? It will change over time, and it will occasionally need to be burped, but it's rather cute, I think, at this stage. Anyway, that process of extinguishment is the key to considering the rights of purchasers who take in the ordinary course of business. There are detailed priority rules. There are default priority rules. There are new priority rules dealing with purchase money security interests, where, for example, you acquire money from a lender for the specific purpose of buying new equipment or inventory or whatever. They will have a priority interest. That's a purchase money security interest. That's true under the existing law. There'll be specific priorities dealing with that under the new regime. The difference is, in order to acquire that purchase money security interest priority, you have to register. Under the current law, you don't have to register. And those purchase money security interests gain priority by ambush because people don't know about them. Receivers don't know about them. The B&B forklift case recently is a reminder of that. It surprised a receiver who was startled when someone raised a purchase money security interest against him because he didn't know someone else had a claim on the property because it wasn't registered. It will have to be registered under the new regime, and that's a bonus. There'll be priority rules for deemed security interests like reservation of title clauses. That's a plus. In the past, again, they were security interests by stealth. They didn't have to be registered. Now they'll have to be registered and perfected. There are new priority rules dealing with accessions, improvements to property, commingled goods. Remember, they were a problem with reservation of title clauses. There'll be new rules dealing with all these types of interests. There'll also be new rules dealing with enforcement, and we'll look at those in more detail. These enforcement provisions offer some pluses and minuses for secured parties. They're not all good. Thank you. And finally, on benefits, the general law is not excluded. This is not a code. It's fairly comprehensive, but it's not a code. There is still room for principles of estoppel, marshalling, constructive trusts and so on to operate. And that's true under the general law. It's still true under this new regime. Thank you. What about the benefits of the regime? Well, Access Economics was commissioned to conduct a study of the potential benefits of this new regime. And they've identified a potential cost saving in a reduction in the interest rates that would normally be charged for loans secured on personal property in the order of 3 to 4%. Now that's loans secured on personal property, of course, which is higher interest rates than the cash rate, much higher. Now, that may be the case when the regime settles down, but there are going to be considerable costs incurred in complying with the new regime and in getting the secured parties' affairs in order to enjoy the benefits of the new regime. So one doubts whether those cost savings will be immediate. They also perceive that there'll be some cost savings in lowering barriers to entry into this secured finance area, and that will hopefully provide more competition. Now, there's almost a touching faith that these cost savings will be passed on to consumers. I'm too cynical to believe that, but there will be some cost savings to the economy somewhere. It won't necessarily reach the consumers. At least the government believes that this new regime is worth implementing. It has allocated $113 million over the next 5 years to implement this new regime. It's busy spending that money, compiling the register and devising the register and sorting out the regulations. The Attorney General's Department is working feverishly on these projects at present. There's a special section of Attorney Generals devoted to this. It seems as if the regime's coming. And the current word is it's going to start in May 2010. There's been a recommendation that it be deferred until May 2011, but the government's still considering that recommendation. It hasn't embraced it yet. And the latest PPS newsletter coming out of the Attorney General's Department says commencement date is May 2010. So watch that space. What impact will that new regime have on security agreements? Well, it leaves them intact. It doesn't annihilate existing security agreements. They're left intact. It doesn't derogate from any rights or remedies secured parties have under existing agreements. If, as a secured party, you're entitled to appoint a receiver or receiver and manager, you'll still be entitled to appoint a receiver or receiver.